Okay, Mansi, please switch on your camera and start.
Success is not final, failure is not fatal. It's the courage to continue that counts. A very warm afternoon to one and all present here. I am Mansi Srivastav on the behalf of Training and Placement Cell, Department of Law, Prestige Institute of Management and Research, Indore. It's an immense pleasure to welcome our esteemed guest, Mr. Amir Bhavani, sir, Mr. Shubhang Kare, Placement Cell Officer, respected faculties and all dear students. Department of Law, Prestige Institute of Management and Research is one of the leading private universities dedicated in imparting education to both undergraduate and postgraduate level. The institution is accredited with NAC grade A++ and approved by Bar Council of India and also affiliated to Devi Ahilyabai University Indore. Its pioneering and indigenous education experiment have set it apart from other law colleges in city and region. Now, I would like to invite Mr. Shubhang Kare sir to brief about this knowledge series program. Sir is currently a placement cell officer, assistant professor at Department of Law, Prestige Institute of Management and Research. Sir has completed his graduation and post-graduation from Christ University, Bangalore. Also, Sir is a PhD scholar. Sir is having experience as training and placement officer with demonstrated history of working in higher education industry. Over to you, sir.
Thank you for the kind introduction, Mansi. And I welcome Mr. Amir Bhavani, sir, Principal Associate at Dheer and Dheer Associates, Hyderabad, who has joined us today to give an insight on Insolvency and Bankruptcy Code 2016 and Training and Placement Cell, Department of Law, PIMR Indore, conducting this daily session with the name of Knowledge Series, a training program, with the objective to groom students and make them ready for future challenges. In this training program, our executive and academic council decide the subject for every month, which subject we are going to deal with, and in every month or two we conduct the quiz competition at the end, so that student can judge on the basis of whether what they have learned or not. Also, the main motto to start this knowledge series or training program is that, being an academia, I have been seeing in every law school or in every law college, a course plan has been designed on basic subjects of law like IPC, CRPC, constitutional law, family law, etc., which are an integral part of law even before the independence, even after the independence, and not denying the fact that these subjects are equally important, or we can say very, very important. But the emerging fields of law like IBC, RERA, insurance law, and energy law, and also IPR are kept as an optional subject in the curricular of law, right? So our motto behind this knowledge series or training program is to enhance law students' knowledge by making them understand emerging field of law, and to motivate our prestigians. In the end of every month or two, as I said, we do conduct in-house quiz competition on the selected subject, and in this quiz competition 1,000+ law prestigians participate, and we appreciate them by providing amazing gift prizes. And I'm very glad today that Mr. Amir Bhavani sir joined us today for the session, and he is going to majorly discuss on 3 points of IBC, or I can say 3 major points of IBC, that is the filing procedure of CIRP, corporate insolvency resolution process, and initiation of liquidation under IBC, and the third very important point, that is clean slate theory, right? So I will not take much time, and thank you once again, Amir sir, to join this session, and thank you so much. Thank you, Mansi.
Thank you, Shubhang sir, for providing a brief of knowledge series training program. Today we have amongst us Mr. Amir Bhavani sir, Principal Associate at Dhiren Dheer Associate. Sir is a postgraduate in MBA from ICFAI University, completed his postgraduate and graduate from Osmania University. His core expertise lies in dispute resolution, especially involving Insolvency and Bankruptcy Code 2016, bankruptcy law, and general corporate. Sir regularly appear before various judicial and quasi-judicial authority, including High Court, Debt Recovery Tribunal, National Company Law Tribunal. He advised significant number of companies, creditors, also other stakeholders to identify and adopt most suitable and approach to deal with the complex web of possible outcomes and legal strategies to effectively deal with aspects of corporate insolvency. We welcome you, sir. In today's session, sir is going to enlighten us about IBC 2016, as it is only also explained by Mr. Shubhang Khare. Now we will be resuming with the session. All the participants are requested to put their queries in the chat box or can raise their hand. After the session, the queries will be answered by sir. I also request all the participants to mute themselves and switch on their video camera. Now I request Mr. Amir Bhavani sir to take the session forward. Over to you, sir.
Thank you so much, Mr. Shubham. Thank you so much, Mansi. I hope I am visible, audible, and you people are also able to see the presentation on the screen.
Yes, sir.
Great. So thank you once again for such a lovely and warm welcome. Now let us begin with the introduction of Insolvency and Bankruptcy Code. So Insolvency and Bankruptcy Code 2016 regularized the insolvency resolution in a time-bound manner. So there were basically three objectives, or there are basically three objectives. The first one being a resolution of the corporate debtor, maximization of value of the assets, and balancing the interest of all the stakeholders. Right. So what is the minimum default for insolvency and liquidation under part 2 of IBC, that is under section 4? So minimum amount of default is ₹1 lakh, wherein the central government may by notification can increase the minimum threshold amount, which cannot be more than 1 crore. And due to financial distress caused due to COVID-19, the said threshold was increased from ₹1 lakh to 1 crore, while notification dated 24th March 2020, and which pretty much is still in place. So right now the threshold limit is 1 crore. So if there's a default of more than 1 crore, then only IBC and an IBC petition can be filed. So let us see who all can initiate the CIRP, that is Corporate Insolvency Resolution Process. So there are three categories of applicants who can initiate CIRP. First is the financial creditor under section 7. The second is operational creditor under section 9. Section 8 is a demand notice, which is a prerequisite of section 9. And under section 10, the corporate debtor itself can initiate, being a corporate applicant. So initiation of CIRP by a financial creditor. So who files? So financial creditor either by itself or jointly with another creditor or any other person on behalf of financial creditor can file section 7. When this can be filed? When an occurrence upon an occurrence of a default. Default includes a default in respect of a financial debt owed not only to the applicant financial creditor but to any other financial creditor of the corporate debtor. And a default, what forms to be accompanied with the application? So an information utilities have been established under this IBC, and they also work under the Insolvency and Bankruptcy Board of India, IBBI. So they will a financial creditor will have to give all the list of the defaulters and have to register those names with all the required details with the insolvency utilities, information utilities. And that statement has to be annexed with the application. Name of an insolvency professional who would be proposed to act as an interim resolution professional, IRP, and any other information as specified by the board. So basically, you'll have to set right that there is a default, and you'll also have to name a insolvency professional. So application by a class of financial creditors. So over here, we'll see jointly by not less than 100 of such creditors or 10% of the total debt under the same class. This has also been provided for the allottees. So if a real estate project is there, so the allottees, not less than 100 of such allottees or 10% of that amount of the debt of the whole, the whole or the total quantum of the debt of the debtor. So if they they come under this specified threshold of this 1 crore as well as 100 or 10%, then only they can initiate. So what will happen when the application is initiated under section 7? So the adjudicating authority within 14 days of the receipt of the application ascertains the existence of a default from the records of information utility or other evidences as provided by the financial creditor. If it's not there, then it has to be rejected. So the AA to admit a section 7 application has to satisfy these two things, that there's a default and there are no disciplinary proceedings pending against the insolvency professional who has proposed to be the IRP or RP. And failure to fulfill this criteria results in a rejection of the application after the AA gives applicant notice to rectify such defects within a period of 7 days. So if there are some defects, like for an example, if you're unable to satisfy that there's a default, or if the IRP whose name has been proposed, and if there are some disciplinary proceedings pending against that IRP, AA, that is adjudicating authority, that is nothing but National Company Law Tribunal, would give you 7 days time to rectify such defects. CIRP commences from the date of admission of the application. The AA to communicate the order of admission to the application to the financial creditor and the corporate debtor. So if there is an admission of section 7, it would be communicated to both the parties. But if there's a rejection, only to the FC, financial creditor. So now let us see how the process goes for the operational creditor. So first they have to give a notice under section 8, and that demand notice has to be provided with all the invoices. And within 10 days of such demand notice, the corporate debtor should reply, either stating that they have paid the amount or there is a pre-existing dispute. So now the next step for the operational creditor would be section 9. So application of initiation of CIRP by operational creditor. So 8 was the demand notice, 9 is an application for initiate the CIRP. So operational creditor may file an application before AA if it does not receive the payment from the CD or the notice of dispute within 10 days of the delivery of the demand notice. So these are the two prerequisites. And the applicant operational creditor may propose a resolution professional to act as IRP. So under section 7, financial creditor shall provide a name of an insolvency professional. Under section 9, for the operational creditor, they may propose. So I'm sure being law students, you know the difference of may, shall, and the whole jurisprudence evolved around those two words. What all needs to be accompanied with section 9? So copy of the invoice demand, that is the demand notice with the invoice, an affidavit that the CD has not paid or we haven't received any notice of dispute, and the certificate or the bank statements from the banks or the financial institutions stating that no such amount has been received by this operational creditor from this corporate debtor, and record from the information utility. But this is if available, because for section 7 it is mandatory, but under section 8 and basically section 9 it is not mandatory because it states if available. So it may say, like, for an example, the operational creditors would be the people who will give you goods and services, who will provide the corporate data with goods and services. So they may not be in a position to do all this, that there's a default and I'm able to prove it. So for that, the legislature is a bit kind enough. So they have not put this stringent burden upon the operational creditors. And by any other means or by any other proof, if the operational creditor is able to satisfy that there is a debt which has not been paid. So the requirements for admission of application. So the application is to be complete. There is no payment of the unpaid operational debt. The invoice or the notice for the payment of CD has been delivered by the operational creditor. No notice of dispute has been received by the operational creditor from the corporate debtor. There is no record of dispute in the information utility, and there are no disciplinary proceedings against the proposed RPs. So, and the order of admission would be, or the rejection would be given in 14 days. And if there are any issues, obviously AA would give the chance to the creditor to revise, to rectify those defects within 7 days of time. Now let us see the very informative landmark judgment. And for us who are practicing before NCLT, National Company Law Tribunal, or AA, adjudicating authority, as they say, this is more like a Bible for the operational creditors, Mobilox versus Kirosa. So what has happened here? So over here, the Honorable Supreme Court has stated that the word "and" is to be read as "or." So if there is a dispute, but there may not be a civil proceedings filed or an arbitration proceedings invoked, still, if the corporate debtor via some communications, emails, letters, any of the correspondence is able to prove that there is an existence of dispute, then they are out of the clutches of IBC. But there has to be a pre-existing dispute. That the Honorable Supreme Court was very clear that the existence of dispute or suit or arbitration proceedings necessarily be pre-existing. That is to say, it should exist prior to receive of the demand notice. So it's not like you give a Section 8 demand notice and then you raise a dispute and then comes Section 9. No, it has to be prior to the demand notice, because Section 9 would follow Section 8, the demand notice, and demand notice is a prerequisite under Section 9. So the Supreme Court has given a plausible contention test. Now let us see what is that that test. So there are 3 questions which are to be asked by the adjudicating authority before admitting or rejecting the Section 9 application. Whether there is an operational debt of more than 1 crore as on date, because it was 1 lakh, but now it is 1 crore. Whether the documentary evidence provided with the application shows that the debt is due and payable and has not been paid till date. And whether there is an existence of dispute between the concerned parties, or is there any record for the same. So now let us see, we have seen Section 7 by financial creditors, Section 9 by operational creditors. Now let us see how the corporate debtor can itself initiate the CIRP proceedings under Section 10. So corporate applicant under Section 5, Subclass 5 means corporate debtor or a member or a partner of the corporate debtor authorized and an individual in charge of managing the operations and resources of the corporate debtor, that is managing director, CEO, executive director, or a person who has the control and supervision over the financial affairs of the corporate debtor. So these people would be termed as corporate applicant, and then they can initiate CIRP, that is corporate debtor itself initiate CIRP against itself. So what is a prerequisite here? Where a CD has committed a default, a corporate applicant may file an application for initiation of CIRP under Section 10. So application to be accompanied with what? So what all section the corporate applicant under Section 10 should accompany? So information relating to the books of accounts and such other documents or for a specified period. Information relating to insolvency professional proposed to be appointed as IRP, and a special resolution passed by shareholders or a resolution passed by 3/4 of the partners of the corporate debtor. So these are the prerequisites. And within 14 days, if the application is complete and if there are no disciplinary proceedings, it will be admitted or else it will be rejected. And for any defects, 7 days time would be given by the adjudicating authority. Now, there was a suspension for a year, that is section 10A kicked in because of the COVID-19 pandemic. So that has been put into force by our Honorable Finance Minister, Mrs. Nirmala Sitharaman, from 25th of March 2020, and that expired on 24th of March 2021 this year. So as on date, there is no suspension. You can very well initiate CIRP, but for that 1 year and the defaults of that 1 year, for that COVID period, you cannot initiate CIRP. So this is in a nutshell what we just discussed, the admission and rejection for initiation of section 7, 9, and 10. And within 14 days, A is to take a decision. So when it will be admitted by a financial creditor, when it will be admitted by an operational creditor, and when it will be admitted by the corporate debtor, section 10 application. So the Supreme Court in the matter of Surinder Trading Company versus Jugilal Jute Mills Company Limited held that the mandate of section 7 subclause 5, 9 subclause 5, and 10 subclause 4 is a procedural in nature, and thus it's directory and not mandatory. What are these sections? The section which I'm telling you again and again, within 14 days, within 14 days. So to be honest, on practical, for all practical purposes, I'll just state it here that practically it is not 14 days. And Supreme Court has also stated very clearly that it is only a procedural thing, but it is, and hence it is directory, it is not mandatory. So it would take more than 14 days for an admission order rejection. So who cannot file for CIRP? The corporate debtor obviously undergoing a CIRP cannot initiate one more. A corporate debtor having completed the CIRP 12 months preceding the date of making of the application, or the corporate debtor or a financial creditor who has violated any of the terms of the resolution plan, which was approved 12 months before making of an application, or a corporate debtor in respect of whom a liquidation order has already been passed. So now let us see the time limit for completion of CIRP. Obviously now CIRP is initiated. Let us see how it goes through, right? So 180 days is from the date of admission. Can also be extended by 90 days by the decision of the COC with 66% of voting, but it necessarily have to be concluded within 330 days. It cannot go beyond 330 days. Now for this also, Honorable Supreme Court in the case of SR Steel stated that the requirement of 330 days completion is ordinarily and hence not mandatorily, because it may take some time. There may be some corporate debtor for which the time may take some more time for it to get concluded because of the peculiar nature. Like for an example, I'll give you, a hospital is there, or a newspaper agency is there, or something like SR itself, wherein the whole steel plant is there and a lot of stakeholders are there, and it's a big stake corporate debtor, wherein the whole process would be a very tedious one. So it may not get concluded in 330 days. Now, if it is filed, can it be withdrawn? Yes, under section 12A. How it can be withdrawn? So the application for withdrawal, it's to be made by the applicant with the approval of 90% of the committee of creditors. Who are those committee of creditors? Committee of creditors are those people, like for an example, the banks and financial institutions are the members of committee of creditors. Now, what happens is, once the petition or application under 7, 9, and 10 is admitted, IRP would make a public announcement. And after that announcement, the IRP would call for the claims from the creditors. Out of those claims, the claims of banks and financial institutions wherein the time value of money is involved, those people would be categorized as financial creditors. Out of those financial creditors, the unrelated party or the unrelated financial creditors would constitute the committee of creditors. So that committee, so just keep in mind the operational creditors of the corporate debtor, that is the people who give services or goods or the employees, they would be out of the COC. They would not be the they would not be the part of the COC. They can still come if they are more than 10%, but still they can only observe. So the withdrawal would be made, then application would be made by the applicant with the approval of 90% of the COC. If application is made after the issue of invitation of expression of interest, applicant to provide reasons. So like, you cannot withdraw at the fag end. Like if the corporate debtor is settling with you when in the initial stages of the CIRP, that is fine. But if the whole process has gone through, claims have been, the claims have come up and they have also put it into force, the COC has been constituted, expression of interest for some other person, or that is what we call as resolution applicant to come into the picture has also been given, that would not be a proper way to go ahead for withdrawal. If it is there, then at that time, specified reasons are to be given that why at this fag end, this CIRP is to be withdrawn. Application is made in form FA and it is to be accompanied by the bank guarantee that whatever expenses are there or which have been incurred by the interim resolution professional are to be taken care of. So either they can pay or a bank guarantee is to be given. Then IRP submits application on behalf of the applicant within 3 days of the receipt under regulation 30 of CIRP regulations. And adjudicating authority may allow for withdrawal of the application. Now, there was one very interesting case, Brilliant Alloys versus S. Rajgopal, wherein the Honorable Supreme Court stated that the insolvency proceedings can be withdrawn even after the invitation of resolution plan. So it is not a watertight thing or one size fits all thing. It has to be taken, all the facts as well as the sector wherein the corporate debtor is there is to be taken into consideration before taking such a drastic step. Now, what will happen once the CIRP starts? I already told you in a nutshell, but now let us go through the process. So admission of an application under 7, 9 or 10. Moratorium is declared under section 14. IRP is appointed. Public announcement would be given and where IRP would call for the claims within 3 days of time. What is moratorium? Moratorium is defined under section 14. So on the insolvency commencement date, the adjudicating authority by order declares moratorium prohibiting these all things. What are these all things? The institutions of suits or continuation of pending suits against the corporate debtor, including the execution of any judgment, decree by any court of law or tribunal, or any arbitration proceedings, or any surface proceedings, or there's a stay on transferring, encumbering, alienating, or disposing of by the CD any of its assets, and the recovery of any property by any owner or lessor where such property is occupied by or is in the possession of the corporate debtor. So basically, it's a standstill thing. It's a status quo. Wherever the legal proceedings are, what are the assets, where the things are, they should stand still. What is the essence of moratorium? A period wherein no judicial proceedings for recovery, enforcement of security interest, sale or transfer of assets, or termination of essential contracts can be instituted or continued against the corporate debtor. A standstill period during which the creditor cannot resort to individual enforcement, which would frustrate the object of CIRP. What are the exceptions of moratorium? Supply of essential goods or services as may be specified in or as terminated or suspended. So what are the essential goods and services like electricity, water, telecommunication services, IT services? Now, over here, one distinction has to be made. See, water for drinking and sanitation purposes is a different thing. But water in a hydro power plant is an input. So that input is a good or services, right? So that cannot be an exception. So the supply of goods and services is critical to protect and preserve the value of CD and manage the operations of the CD as a going concern. Now over here, if you see in the same example, that if the hydro plant is on, where the labor is there, where the corporate debtor is a going concern, and the electricity is being generated, power purchase agreement is in place, and the corporate debtor is very much running the whole operation. So at that time, this supply of goods and services which are critical to protect and preserve the value of CD would come into place. And at that time, that water also has to be supplied. So the moratorium shall not apply to such transactions as may be notified by central government in consultations with the financial sector. Moratorium shall be enforced till the completion of the CIRP. So this will be there so that the whole process becomes smooth. Like for an example, if there's some litigation ongoing and if there's a resolution applicant who has come up, and then you suddenly know that the corporate debtor has lost that case, the applicant who wanted to invest or to buy out this will just come back or will just put a step back. That sorry, I did not agree for this. So everything has to be standstill so the resolution applicant knows that what he is paying for. The creditors know that what kind of haircut they are getting and for what amount. And the IRB is also able to manage. Because see, if there's a big concern, one single person may not be able to manage if it's just fluctuating, even with the help of the erstwhile management and the workmen of the corporate debtor. But over here, there's one very important thing, that any license, permit, registration, quota, concession, clearance, or similar grant or right given by the central government, state government, everything should continue. So let us take an example of an hospital in a COVID time. If a corporate insolvency resolution process has been kicked in, that is against a hospital, and if there's like in this COVID scenario, there's this oxygen supply agreement, so that becomes very critical at this point, right? And that license or that permit or that agreement is to continue so that the hospital can run. Suddenly stopping that would not help the corporate debtor keep it in a going concern format, and thereby you're losing out on the whole core of the CIRP or IBC, that is maximization of assets. But in the Canara Bank versus Deccan Chronicle Holdings Limited, NCL80 stated that moratorium would not affect any proceedings initiated before High Court and Supreme Court. That is what we call it as SLPs and writ jurisdictions. So that won't be affected. That can still go on. Now, let me give you the overview of CIRP. So now let us see how the whole CIRP works. But I've made it in a process or a flow format so it does not become too dry. So default occurs, obviously, yes, then only you'll be able to do it. And then you file an application. If admitted, resolution process commences. Moratorium is kicked in. IRP is appointed. He goes for a public announcement and call for submission of the claims. Then the committee of creditors is constituted under section 21. Meeting would be there for the committee of creditors. They'll decide on how the corporate debtor is to go through and what are the evaluation criteria for the resolution applicant to come in. Appointment of resolution professional. So what will happen? I'll tell you this. So IRP is appointed by NCLT. In the first meeting of the committee of creditor itself, the committee is to take a decision whether that IRP is to continue. If yes, then that IRP becomes resolution professional. IRP is interim resolution professional. IRP is resolution professional. No, if the COC says, no, we don't want this IRP to continue, then it has to be replaced. So appointment of resolution professional takes place at that time. Then resolution professional conducts the whole CIRP and manages the operations of the corporate debtor. That is, he takes care of the whole management, and he steps into the shoes of the board of directors. And then he prepares the information memorandum, that is the whole chart with all the information of the corporate debtor. And because see, if someone wants to become a resolution applicant who is interested in this corporate data, should get all the information, and that information would be available in a document known as information memorandum. Then the submission of the resolution plan by the resolution applicant. If it is approved by the COC, it goes for the test for the approval of the Honorable Adjudicating Authority, that is NCLT. And if it is approved, there lies an appeal provision as well under section 32. So over here, I've just concluded the whole CIRP process, not gone into too detailed thing because our topic was the filing purpose. Now let us see the second topic for today's webinar, liquidation. So now we have seen if the resolution plan comes, a resolution applicant is there, CIRP is there, and the whole company gets revived. Now, in what all scenarios the company is not revived and liquidation for the company starts? So circumstances of liquidation, these circumstances are given under section 33. Now let us look at all these circumstances. That the NCLT does not receive a resolution plan itself within the maximum time given under the CIRP. Second is, there is a resolution plan, but adjudicating authority rejects the plan because of the non-compliance of the specified requirements under IBC and the regulations. Or RP at any time during CIRP, but before the confirmation of the plan, informs NCLT about the decision of COC with 66% of vote that the company should be liquidated. Or a person other than the corporate debtor whose interests are prejudicially affected by the corporate debtor's contravention of the approved resolution plan. They can also make an application to AA for liquidation. And AA determines the corporate debtor has contravened the resolution plan. So these are the scenarios when the corporate debtor would be relegated into liquidation. So initiation of liquidation under section 33. So AA will pass an order requiring the corporate debtor to be liquidated as under IBC and requires such an order to be sent to the authorities. So what are these authorities? Obviously, it is the listed companies and SEBI and all the securities board and registrar of companies, regional directors, and issue a public announcement stating that the corporate debtor is in liquidation. And the effect of this order is that this order discharges all the officers, employees, workmen of the corporate debtor, except the business of the corporate debtor is continued during the liquidation process as well by the liquidator. So now you'll ask me, who is the liquidator now? I have explained IRP, I have explained RP. Now who becomes the liquidator? So this has been given under section 34. Once order for liquidation of the corporate debtor has been passed under section 33, the resolution professional appointed for CIRP shall act as a liquidator unless it has been replaced by the AA. So AA by an order replaced the resolution professional if the resolution plan submitted by resolution professional under section 30 was rejected for the failure to meet the specified requirements. So over here they are talking about the incompetency of the RP. Or the board recommends that the replacement of RP to AA for the reasons in writing, or the resolution professional fails to submit the written consent. He himself wants to say, no, I'm sorry, I don't want to be a liquidator of this company. So in these scenarios, he'll be replaced or else he'll only be the liquidator. So once appointed as liquidator, the power of the board of the directors, key managerial personnel, and the partners of the corporate debtor cease to have effect and shall be vested in liquidator. And all the personnel of the corporate debtor should give the support to the liquidator. And liquidator would also charge its fee. We'll also see what is the fee structure for the liquidator in the next coming slides. So let us look at this NCL 80 judgment of last year, Punjab National Bank versus Kiran Shah, the liquidator, that once the liquidation starts, the committee of creditors has no role to play, and they are simply a claimant whose matters are to be determined by the liquidator and cannot move an application for removal. Because see, if I told you IRP, they can change it to RP, they can remove RP. But once the liquidation proceeding starts, COC, no, sorry, they cannot, because COC, the mandate of COC ends when the liquidation proceedings commences. Yes, so liquidators fees. This is under regulation 4. So it is in accordance to the decision of COC under regulation 39D, or is the same rate as the RP was entitled during CIRP if an arrangement under 230 is filed. What is an arrangement under 230? It is merger, amalgamation. And it's also a percentage of the amount realized, net of other liquidation costs and amount distributed for the balance period of the liquidation as specified. With effect from 5/8/2020, where a liquidator realizes any amount but does not distribute the same, he is entitled to a fee corresponding to the amount realized by him. But if he distributes is also the same, he is entitled for the fee corresponding to the amount distributed by him. So it's realized or distributed. Liquidator is entitled to receive half of the fee payable on realization only after such realization amount is distributed. So he can take half at the time of realization, but the second half or the remaining half is to be only taken by the liquidator once that amount is distributed. Now, what are the powers and duties of the liquidator? These are given under section 35. A liquidator has to verify the claims of all the creditors, control the assets and the properties and the actionable claims of the corporate debtor, evaluate and prepare a report of the assets of the corporate debtor, to take necessary measures to protect and preserve the assets of the corporate debtor, to carry on the business for the beneficial liquidation, to appoint any professionals to settle the claims of the creditors, to institute or defend the proceedings of the corporate debtor, to investigate financial affairs of the corporate debtor for any undervalued or preferential transactions, to endorse negotiable instruments, consult the stakeholders, any other functions as prescribed by the board. So basically, liquidator becomes a board of director. He takes care of everything. Rather, he becomes a managing director. Role and function of the liquidator. So liquidator forms a liquidation estate with the specified assets of the corporate debtor. So all the assets are coupled into one single document, and that is known as liquidation estate. The liquidator has the power to access any information system for the purpose of admission of proof of claims. And he also is duty bound to give the information to the creditors within 7 days if asked for. He has to collect the claims of all the creditors from the records within 30 days of the commencement of liquidation process. And a creditor can vary or withdraw the submitted claims within 14 days. So if a creditor has filed some claim, he can withdraw or vary it in 14 days. Then what happens if all the claims are given? Then liquidator verifies all these claims and either accepts or rejects this claim within the period of 7 days. Now, if he rejects, a creditor has got an appeal under section 42. So under section 42, creditor can approach NCLT stating that my claim has been rejected wrongly. And the value of the claims is then determined by the liquidator in a specified manner. So now this is a very interesting, the couple of slides are going to be very interesting because this gives how the IBC or board of IBBI, that is Insolvency and Bankruptcy Board, or the legislature are proactive. So what they've come up with 30 subclass A from November 2020. What does it say? That creditors who are unwilling to wait for the completion of the liquidation process for realization of their debt can assign or transfer the debt to any other person during the liquidation process. So for an example, I am a bank. I guess that this might take some time, realization, but there's some person who's willing to wait or some entity is willing to wait. I can assign my debt to that person. Accordingly, his name would be changed, but we both will have to approach the liquidator who would put it in the modified list of stakeholders. So this is by the creditor, if creditor is unwilling to wait. Now there's one more provision which also came last year, 37A. NRRA, non readily realizable assets. So which are these assets? These are sundry debts, refunds from government and agencies, contingent receivables, dispute receivables like arbitration and all that. PUFE, preferential undervalued, extortionate, and fraudulent transactions. So these claims or assets, I would say, would take a lot of time. And the liquidation proceedings cannot go on for a lengthy period of time, or can go on and on and on, as we say. So at this moment, the the liquidator would take a decision that I want to assign this debt. So he can very well do so. This is a very proactive measure taken last year under the IBC regime, and which has been accepted by the whole masses with open arms. Now I've been saying what are PUFE transactions. So I'll just give you a brief. There are 4 kinds of transaction: preferential, undervalued, fraudulent, and extortionate. So if this kind of transactions have occurred, so obviously they give some kind of timeline, either 1 year or 2 year preceding the CIRP date. So if this kind of transactions have occurred in the corporate debtor or the corporate debtor's entity, then these transactions are to be reversed, and the ex-management is liable to pay back to the bankers or the stakeholders, I would say. So the under 43 is preferential, under 45 is undervalued, under 49 is fraudulent, and under 50 extortionate transactions. And the period of lockdown is excluded under liquidation process regulation 47A, because I'll tell you the period of liquidation was when IBC kicked in was 2 years, but now the liquidation process is to be concluded within a period of 1 year. So obviously we know because of COVID we cannot do anything. So that period has been excluded. Now let us see what are the implications. So a creditor may choose to relinquish his security interest to the liquidation estate and receive the proceeds of the sale. So like I, for an example, I'm a bank and I have a security interest, and more layman language, I'll say I have a property which has been mortgaged, right? So I'll have to take a decision, being a creditor, that do I want to relinquish my security interest and join the other creditors under liquidation estate, or I would want to pursue my security interest separately. So that option is given to the creditor. And the liquidator is to verify such security interest and permit the secured creditor to realize only the security interest that is proved. And the liquidation assets are distributed in a specified order as per 53. How? We'll see 53, the waterfall mechanism, how they are distributed, right? And once the assets of the corporate debtor has been completely liquidated, the liquidator makes an application to AA for dissolution of the corporate debtor. And AA then makes an order for the corporate debtor that it shall be dissolved, and the corporate debtor is dissolved accordingly. And this order is to be given to the ROCRD and all the authorities. Now let us see what is the priority for distribution in cases in the case of a liquidation. This is under section 53, which we call it as a waterfall mechanism, because the higher the level, the more chances of getting your dues money back. So the first and foremost is the full CIRP cost and the liquidation cost. The second is the workman's due for 24 months and debts for secure creditors with relinquished security. Then comes with the wages and unpaid dues for the employees other than workmen. Then the financial debts owed to unsecured creditors. And then the central and the state government's dues. And then the remaining one, then the preferential shareholders, and then the equity shareholders. I'll tell you, with our experience, it usually ends at maybe level 3 or maximum at level 4. It's hardly going to level 5. So obviously CRP costs and liquidation costs are paid in full. Workmen's are paid 24 months of their dues. Secure creditors, obviously they'll take a haircut, and they'll also be paid some amount. But then by the time we reach to financial debts owed to unsecured creditors and the central, the state government dues, we don't see that much amount of realization under IBC. Now, distribution of unsold assets. So like what happens when the assets are unsold or if there's no buyer for that? So obviously then it can be distributed amongst the stakeholders, for which the liquidator will have to take the permission of the NCLT. Now let us come to the third and the final topic for our discussion in today's webinar, that is the clean slate theory, and with a reference to personal guarantors. So now let us understand what is clean slate theory. So it comes from section 31 of IBC. So if AA is satisfied that the resolution plan is approved by COC under 30 subclass 4 meets the requirements as per section 30 subclass 2, it shall by an order approve the resolution plan. Now, once the order is out, that is once the resolution plan is approved by NCLT, it is binding on the corporate debtor, its employees, members, creditors, all the creditors, including the central government, state government, or any local authority to whom a debt in respect of payment due arising is pending as on date, and such as authorities to whom statutory dues are owed, guarantors, and other stakeholders. Now just see the implication. It is like when the plan is approved, that is binding upon the whole world. There ends the matter. So this is the clean slate theory. Now, how the jurisprudence has evolved here. So this clean slate theory, this term was coined by Honorable Supreme Court in the SR Steel judgment. So once a resolution plan is approved by COC, it shall be binding on all the stakeholders, as we have just seen. And this is as per section 31 subclause 1. Now let us see the inverted comma ones in the below part of the slide. Let us read and analyze that. What did Supreme Court held? A successful resolution applicant cannot suddenly be faced with undecided claims after the resolution plan submitted by him has been accepted, as this would amount to Hydra head popping up, which would throw into uncertainty amounts payable by a prospective resolution applicant who successfully take over the business of the corporate debtor. All claims must be submitted to and decided by the resolution professional, so that a prospective resolution applicant knows exactly what he has to be paid in order that it may then take over and run the business of the corporate debtor. This the successful resolution applicant does on a fresh slate. So now, if a resolution applicant is there, that applicant should know that what I am paying for, what will be my assets, what will be my liabilities. It cannot keep on coming once he takes care of the business, because he, if is coming or if is investing, then he should be sure that how he's going to go about it. Otherwise, we may also see one more CIRP of the same corporate debtor, which is with the new resolution applicant, that is a new management, and it's a never-ending process. So revival doesn't happen here unless and until a clean slate is given for to the resolution applicant to run the business. Now, there was one more case wherein Rajasthan High Court has also given the same kind of a treatment. This is Ultratech cement case in 2020 itself, wherein the GST demands were there for the period prior to the date of finalization of resolution plan. So the Honorable High Court held that as per section 31, central government, the state government, or any other local authority to whom a debt in respect of payment of dues arising under any law for the timing in force are owed have been brought under the umbrella of the resolution plan approved by AA, which has been made binding on such governments. So like, if you have filed a claim or if you haven't filed a claim, like for an example, you were sleeping over your rights, you didn't even know that CIRP commenced and my claim I haven't filed with the resolution professional. No matter what, the resolution applicant is not bound by that. So that's a clean slate. Now let us look at section 32A. So the liability of the corporate data for an offense committed prior to the commencement of CRP shall cease, and no action can be taken against the property. Now over here, we'll have to understand it's liability of the corporate debtor, not by the management. So the management, so if you remember now, if you recollect, PUFE transactions were there: preferential, undervalued, fraudulent, and extortionate. Those transactions were done by whom? By the ex-management. So those transactions are not, no, they don't go away, or they are, neglected, I would say. Those transactions are there. If AA approves, then even at the approval of the plan, those liabilities does not get extinguished. Those liabilities still stays, and the ex-management is still liable to pay to the stakeholders. But when we are talking about a corporate debtor, obviously being law students, we all know that corporate debtor, that is a company, is a separate legal entity. So the separate legal entities, so whatever offenses are there of the corporate debtor, that is the entity, not the management. We'll have to differentiate here very precisely. So those things would get extinguished. And then in 2021, this year, the issue came up before the Honorable Supreme Court, the validity of section 32A, wherein the Honorable Supreme Court stated that as per the SR judgment, the view taken is very much clear. And they also relied upon the report of the Insolvency Committee and also the report of the Standing Committee of Lok Sabha. And it is just a clarificatory in nature. So they stated, yes, the clean slate theory has been approved once again, because the successful resolution applicant cannot be faced with undecided claims. Now, let us see what Supreme Court this year also stated further. So it is not as if the wrongdoers are allowed to get away. They remain liable. The extinguishment of the criminal liability of the corporate debtor is apparently important to the new management to take a clean break with the past and start on a clean slate. So we must also now overlook the principle that impugned provision is a part of an economic measure. So over here, what the Supreme Court states is, see, if any wrongdoing is there by the ex-management, they'll still pay for it. And the last portion, that is in the below part of the slide, I should read, and you should also pay attention. This is very important. It must be remembered that the immunity is premised on various conditions being fulfilled. There must be a resolution plan. That plan must be approved. There must be a change in the control of the corporate debtor. The new management cannot be a disguised avatar of the old management. It cannot even be a related party of the corporate debtor. And the new management cannot be subject matter to an investigation, which has resulted in material showing abetment or conspiracy for the commission of an offense and report of complaint filed thereto. These ingredients are also insisted upon for claiming exemptions of the bar from action against the property. So over here, as I was saying, Supreme Court has demarcated the whole thing, that is ex-management is still liable, separate legal entity, new management is not liable for any earlier wrongdoing. Now, this is also a very, very recent judgment. I guess this came this month, I think last month, yeah. So Ghanshyam Mishra and Sons versus Edelweiss ARC. What was the issue involved in this case? So whether after the approval of the resolution plan by AA, a creditor, including the central government, state government, or any local authority, is entitled to initiate any proceedings for recovery of AA for the dues of the corporate debtor. So what did Supreme Court say? That after the amendment of section 31, any debt in respect of the payment of dues arising under any law for the timing in force, including the ones owed to the central government and state government or any local authority, which does not form part of the approved resolution plan, shall stand extinguished, and no proceedings in respect for the period prior to the date of on which the AA approved grants is approval to the resolution plan. So either you have filed a claim or you haven't filed a claim. you have no remedy once the plan is approved. Because the only reason for that is if you are given a remedy, you are directly discouraging anyone that is a resolution applicant to come forward and invest in the company or to take care of or to take over of the management of the corporate data. This is what I just said. Now, what are the exceptions to this? The exception is the corporate guarantor. So, Honorable NCL80 very recently in the Athena Energy Ventures Private Limited stated that simultaneous application seeking initiation of CIRP against both the principal borrower and the corporate debtor for the same debt and default is allowed. So a creditor can always initiate simultaneous proceedings against a guarantor and a debtor, right? Clause in resolution plan which states that the liabilities including the corporate debtor guarantee stands extinguished on approval of the resolution plan does not mean that financial creditor has accepted the amount in full and final settlement of its dues. This was held very recently in Kanwar Raj Bhagat versus Gujarat Hydrocarbons and Powers SCZ by NCL80 very recently this month. So right to recovery of the debt against the party, that is a corporate guarantor against whom the CIRP has been initiated, is extinguished, but financial creditor can recover the remaining dues from the corporate debtor. Now, why I'm showing you all this exception is, you'll have to understand that the creditor can initiate simultaneous proceedings, can approach NCLT for an application to initiate CIRP against the corporate debtor or the corporate guarantor or both in any manner. That is, they can either file first against the corporate debtor or first against the corporate guarantor or together. So debtor and guarantor, they both have the liabilities which is being shared. Now let us come to the last part, the personal guarantors. Now we have seen the clean slate. Now we understood that initiations can happen against the debtor as well as creditor if they are corporate. What happens if they are personal guarantors? Now with notification dated 15/11/2019, some of the sections and the regulations and the rules were notified by the Ministry of Corporate Affairs, which stated that invocation of personal guarantees and dragging them to the court of law is allowed under IBC. So section 5 subclass 2 defines personal guarantor. Who are personal guarantor? Personal guarantor means an individual who is the surety in a contract of guarantee to a corporate debtor. Where's the jurisdiction? The jurisdiction lies with NCLT. Why? Because of section 60 subclass 2 and 60 subclass 3. Right. It's in front of your screen. You can just have a look. Now, before we go into how the interplay works between the personal guarantors and the clean slate theory, let us understand what Honorable Supreme Court held in SBI versus S. Ramakrishnan. Supreme Court stated that the moratorium under Section 14 would only apply to the corporate debtor and not to the personal guarantor of the corporate debtor. So if there's a 138 matter, which is obviously against the person who has signed, still continues. So that was the case. So moratorium is not applicable, and hence you can initiate proceedings against the personal guarantor as well. Then came this Anil Ambani case, Anil Dheerajlal Ambani versus State Bank of India, wherein the State Bank of India, obviously for Reliance, they've initiated CIRP, which is ongoing. They also invoked the personal guarantee and approached NCLT for personal guarantee application. That was stayed by Delhi High Court on 27/8/2020. And now it is sub judice because there was one matter, there was Lalit Kumar Jain matter, and then this Anil Ambani matter came. And then now I think there are more than 30 matters. Even my couple of matters are also pending there. So it's all the batch of matters which the Honorable Supreme Court is now looking out for. So this matter is sub judice. Why it is sub judice and what Supreme Court is looking out right now? That the main contention of all the parties is only one, that if the insolvency tribunal starts accepting the plea of banks on the personal insolvency as well, it could lead to initiation of insolvency twice for the same debt. Doesn't it mean that you are going for the same debt twice, first to the corporate debtor and secondly to the personal guarantor? And this is still sub judice. There is no order as on date, and everything has been stayed. Now let us see one very important aspect, right of subrogation. I'm sure all of you must have concluded your contracts law. So section 140 and 141 of the Indian Contracts Acts deals with the subrogation. So what subrogation says? That once the surety in a tripartite or a guarantee agreement pays, would now step into the shoes of the creditor and then can take the dues from the debtor, right? That is what the whole right of subrogation is there. But over here under CIRP, now you see the problem that once the resolution plan is approved and made binding on all the parties, including the guarantor, then no rights can be enforced. So subrogation rights cannot be enforced after the approval of the plan, in consonance with the clean slate theory. So you have at one side, you have the clean slate theory that you cannot go and ask RA, resolution applicant, for your payment. At the same time, your right can also be invoked by the creditor, being a personal guarantor or a corporate guarantor. So now you see there's a deadlock. Like if you pay, whom you'll approach, because you cannot approach him. So I'll just conclude right now. We'll have to see this, that the validity of insolvency against the personal guarantors. What will Supreme Court say now? That is it a simultaneous proceedings or no? Because see, one view is of the NCL 80 that simultaneous proceedings can happen for the same debt, for the same due between the corporate debtor and the corporate guarantor. But can it also happen against the personal guarantor? That Supreme Court will answer. So that is first. Second, like for the resolution applicant to effectively run the entity, it is paramount that he receives the corporate debtor as a clean slate. Otherwise, why would someone come and invest? So that's his worry. And the third point is that given the lapse of the right of the subrogation after the approval of the plan, wouldn't this discourage the guarantors to give any more guarantee in the future or going forward? So we'll have to now see rights of three people. First is the creditor. They will have the right to invoke against all the entities, as including the personal guarantors. Right of RA, that he should get a clean slate, and the guarantors that if they don't get a right of subrogation, from where they're gonna recover their amount. And this is it. Thank you. I'll stop sharing and I can take few questions if there are any. Thank you so much, guys.
Thank you, sir, for this enriching session. Now, I would like to ask some of the participants if they have any kind of questions related to the topics, which is explained by sir. You may raise your hand and you can just post your question in chat box.
Student can ask any question if there are any doubt related to any point. I think sir is very clear throughout the lecture.
No, I'll be dead honest. Either I was making them bore, they did not understand anything, or I was very good that they don't have any question. I'll still go with the first one because I doubt that I was so good. So I'm sure there must be questions, but I don't know. Let's see.
Sir, there is one question. By Ms. Sakshi Agrawal. You have just talk about a case which is sub judice. What are the contention for that?
Yeah, so the contention over there is that can there be a simultaneous proceedings against the corporate debtor and the personal guarantor for the same debt? Aren't you going twice for the same debt? Because if you are being satisfied by one, where's the need of going for the second one? And that is why it is sub judice.
Thank you, sir.
Any more question, guys, or you want to enjoy the weekend?
I think there is no more question. So here.
So sorry to interrupt.
Yeah, please.
I having a doubt. Like the grievances are resolved in NCLT only.
What kind of grievances?
So any grievance related to CIRP or IBC.
Yes, so basically the forum is NCLT only under IBC. So IBC only, Insolvency and Bankruptcy Code only talks about adjudicating authority, and the adjudicating authority is as per Companies Act, and as per Companies Act it is National Company Law Tribunal.
Okay, sir. Thank you.
Yes, Mansi, you may conclude.
Yes, please.
So if there is no more question, we'll just end the session by a vote of thanks. So I would like to call upon Ms. Sakshi. She's student convener of Training and Placement Cell, Department of Law. Sakshi ma'am, please.
Good evening, sir. I, on behalf of Placement Training Cell, Department of Law, PIMR, would like to extend my heartiest gratitude and vote of thanks for providing us with your precious time and enlightening us with your knowledge. And this has definitely helped us a lot in learning. And I would also like to thank students for their peaceful listening and cooperation. Thank you. Thank you, sir.
Thank you,
Sakshi ma'am. Thank you, sir. It was a great session. We enjoyed it a lot.
Thank you, Mansi. Thank you, Mr. Shubhank. I hope I did not bore you guys.
No, sir.
Definitely not, sir.
Very clear and very understanding, sir. Very, very good explanation and very easy explanation. Even I have learned various things from this lecture, seriously, sir. And especially that recent cases and judgments which I never heard, sir, till today. That is very good, sir. Very. Thank you so much.
And I would, before we conclude, I'd like to thank two of my associates who are also here, Rishika Kumar and Riya Jai Kumar. So they helped me with preparing this wonderful PPT, and they're also with me in their associates. So thank you for having me, guys, and take care. Stay safe.
Same to you, sir. Stay safe, stay healthy.